Viewers, welcome back to the Personal Injury Law Show. Because of the nature of the topic tonight and the fact that we've been fortunate to get the Professor on board, we won't be doing the mailbag. Professor, just before the break, you were talking about how Mr. Griffiths couldn't get his job back because it was a company's laptop.
Yep.
Does that mean if it wasn't the company's laptop, they couldn't have done anything about him?
In the current state of the law, they couldn't have done a thing because the rule is that if you use your company's communication system, then you might be subject to a whole range of surveillance of your internet, email use and so on. But if you're using a private computer and your employer just happened to engage in some way or another on surveillance of your own computer rather than their computer, the whole case wouldn't have occurred.
But it's pretty unsavoury conduct, isn't it, Alice, with people going on to pornography?
Look, it doesn't help, Tony, and this case, I think, really is also a bit of a case of willful blindness as well. I mean, this guy is using a work equipment to do something contrary to a work policy. There was allegations that he wasn't being totally truthful about his activities and various other things.
I wouldn't say he's blind, because what he did do is try and cover his tracks when they did find him out.
Yeah, look, that's what I'm talking about, and also I just think that you really need to think twice about what you're using your work computer to do, because I think that it's unrealistic to say, well, there's no way they could find out about it. I mean, this is the nature of the topic we're talking about.
Professor, they were obviously gunning for this guy because he was employed with this department for over 25 years.
Yes.
So you gave him the opportunity to get rid of him.
Yes.
Isn't that right?
Well, I think that's probably true, and who knows what the broader context of the relationship between this particular person and the employer was. One suspects that
but they got him.
This is a relatively minor thing, a distasteful thing, but nevertheless relatively minor one, but 25 years service and get the sack for just the use of a work computer, it's pretty tough.
It's funny you say that because there was a time there in our office we employed this system to work out what people are doing with the internet.
Yep.
And we had a similar occasion where a fellow was using it for pornography again. So, and I don't want to say the number of hours he was on it because it's extraordinary. I think you'd have to be there day and night. But anyway, Alice, there's an interesting case of Garcia and CGU. Can you give me some of the facts of his case?
Yes, look, I think we should touch briefly on this, Tony. Essentially, Mr. Garcia was injured at work whilst performing mechanical jobs servicing a vehicle, and he injured his shoulder in a wrench sort of action, and he put in a claim for compensation for weekly payments and medical expenses, or the equivalent, in New South Wales. This fellow was handed around to, I believe, 5 different doctors for the insurer to determine exactly what the nature of his injury was and whether or not it was connected to work. And then the insurer sort of provisionally accepted the claim but kept this guy hanging whilst they kept handing him around to doctor after doctor and also conducting surveillance to work out if the claim was a bona fide claim. Yes. Anyway, it transpired over the course of about 5 months. In the 5th month, they sent him to a doctor, yet another, a 6th doctor, who said, contrary to what the first doctors had said, all 5 of them had agreed that the injury was definitely related to work. But the 6th doctor said he felt it wasn't related to work and it wasn't an injury the worker should be able to recover for. What I find really extraordinary about this case is 2 things. 1, the insurer never bothered to hand the report over until 2 years later when litigation had been commenced, because the claim was eventually denied on the basis of this 1 report and in the face of much more evidence broadly that said that the work was related to the injury and vice versa. And number 2, that he was kept in abeyance, he was surveilled, he never found out about it, and it had such a negative impact upon him. He won in the first instance in the District Court of New South Wales. They said, yes, that's totally unconscionable conduct by the insurer and they weren't acting in good faith in terms of looking after this guy. But the Supreme Court of Appeal in New South Wales basically unanimously overturned it and said the insurer didn't have a duty to clean up their act.
Professor, the significant point in this case is this. The court initially found that the insurer had a duty to act in good faith towards this particular worker. The Court of Appeal said there's no such duty. What's your view about all this?
Well, the whole thing, for me, it seems to me, we're dealing with an attitudinal problem and a problem of what appropriate behaviour by the employer in this particular circumstance is. Now, if the employer delayed the litigation for the purposes of sending this guy to doctor after doctor after doctor after doctor, finally finding one of their own, and if the person then, as in the first instance, won the case, that, it seems to me, is an issue for the court in relation to the award of costs.
Well, he did develop a very, very severe psychiatric condition based on the fact that they mucked him around, for want of a better word.
Yeah.
And that's logical. I mean, if you're going to be mucked around like this, you're going to become severely affected by it, aren't you?
Look, Tony, this gets back to what we were saying earlier. First of all, I think there is an attitude problem. Insurers don't like handing over their precious evidence that really undermines our clients. And second of all, I don't think that we take into account enough the negative effect that these types of surveillance activities have on our clients. Clients can become paranoid, they can become very upset, they feel like they can't leave their home because if they're filmed doing something seemingly innocuous, it can be used against them later on in a courtroom. And I think this is a really serious issue for consideration by people like us. So I think that we really should be looking at some kind of reform of the privacy legislation. We can get hold of this information earlier and it can really affect how you run the claim and it can affect how you look after your client too.
You're the president of Liberty Victoria, Professor. Isn't it a case where this fellow's claim's been held in abeyance for 2 years?
Yeah.
What about his family? What about the fact that he's got a mortgage and expenses, and it's just bizarre behaviour, isn't it?
Well, it's a little bit outside the framework of the civil liberties and human rights issues with which we deal, but nevertheless, we're talking, it seems to me, about a fundamental case of unfairness. And if that
or some
unfairness
sort of procedural unfairness.
If that unfairness is disclosed in the court in the course of judicial proceedings, then it seems to me that the court has a responsibility to make appropriate award of costs or impose such other penalties as may be appropriate to compensate the person for being mucked around.
Professor Annellis, this is a very, very big topic and we don't have a lot of time left. In finalising, what would you say? Professor, where would you like to see the law go?
Well, I think the law should go, we should get proper statutory regulation of workplace privacy. I mean, that's the fundamental thing. And the regulation of workplace privacy ought to, in effect, make illegal unreasonable invasions of individual privacy. So, for example, if an employer decides to engage in the surveillance of an employee for a purpose that is a non-work purpose, that would clearly be an unreasonable invasion of privacy.
And Alice?
Look, Tony,
in brief?
Yes, in brief, I think this affects us as solicitors too, because if we were able to get things like surveillance on our desk a little bit earlier, you can get your client in, you can also get doctors to look at it and comment upon it, which can help you from an evidentiary point of view, and you can also look at what cases really are out there which are worth running and what cases need some reconsideration. And this relates also back to the court system. It's a resources thing for us as well, because you might find there are cases that you've got that may not be so viable because of the surveillance that's been conducted. So,
well, Alice, in brief, myself, we'd save money, would save the court's time.
That's right. We
would not run useless cases and doctors could put the surveillance in a perspective. So on that note, viewers, I want to thank you for watching. I want to thank the Professor for coming on board.
Thank you very
Alice,
much.
Thank you, Tony.
And please stay tuned and stay safe.